What's your client's name?
Last name Ryan Dash Brown.
Okay. Is your client here?
Yes, Your Honor.
Okay. What would you like?
We're asking for you to remove the restriction of prohibiting contact with the complainant.
This is yours, Barbara?
Yes, Your Honor.
Let's talk.
Nice to meet you, appointment. And she's okay with no threatening.
Okay. Come up, sir. Come on up. Is there a protective order in place now? Let's
Yes.
see. Yeah. Sorry.
One of the bonds that.
So, Mr. Ryan Brown, I'm going to amend the conditions. I like to do what the complaining witnesses want. If they want to have contact with you, I'm going to allow contact, but nevertheless, there's no threatening or harassing contact that is allowed. What is threatening or harassing is what they perceive. It's not what you think. I don't care what you think. It's what they perceive. So is that threatening or harassing? It most certainly is, and it can land you back in jail. Do you understand? I don't know what kind of relationship you have with this person, but if it's something that you're constantly butting heads, it's probably not a good idea because you piss this person off and they come back and they say that you're threatening. It's just not going to go well for you. You understand? Okay. You mind applying those conditions? We'll modify the protective order as far as the residential restriction. Everything else will remain effective as in the protective order.
I'm
Okay.
sorry, Judge, I didn't know you did arrange this.
Don't worry about it. I mean, I know you're busy. We'll just get you out of here. It'll take 2 seconds. So
Yeah, there are no conditions.
we have state's bonds conditions. So we'll have it filed now and then we'll print out the MOAB. I'll take off the residential restriction. Then you guys are good.
Thank you.
Don't let him leave though. We'll need him to sign the conditions and then he can go.
Thank you.
All right. Okay. All right.
Judge Typo 21, Johnson, first initial D.
We only have one arraignment?
We have the other one,
You were Mr. Johnson? Mr. Johnson, you charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 18th, 2026, officer with his faculty conduct a follow-up investigation on harassment. Defendant is former Metropolitan Authority employee. Defendant sent the email to complainant, or to 22 complainants that
Oh,
caused
right.
security.
I remember this. Mhm.
That caused security to be implemented. Defendant stated in the email, quote, "You better hope I don't pull up in the neighborhood. It's going to be shit." Defendant was terminated from employment and sending numerous emails to 23 separate employees with intent to harass, annoy, alarm, abuse, and torment. The voicemails also left on from defendant's phone recorded placed in each file. Defendant was informed no longer to contact the employees. Officer informed defendant it is no longer allowed on MTA properties. Defendant became agitated and asked the officer back number. Defendant then sent another email that was vulgar harassing.
Did you catch that? The defendant sent emails to 23 different employees and left a voicemail saying, "You better hope I don't pull up in the neighborhood." And then the judge says, no contact with any of the 22 or 23 people. Here's the legal insight. A no contact order can cover multiple people, not just the main victim. And violation? Automatic jail. No more PR bonds. That's not a warning. That's a promise. So real talk. Should a first-time offender get that many restrictions, or is this appropriate?
So what place is this?
It's a former employee of the Metropolitan Transit Authority.
Right. Okay. That's right. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with any of the people that are listed in this complaint. I think that's to the tune of 22 people.
Yes, Your Honor, about 23.
You were not allowed to have, or 23?
22.
You were not allowed to have contact with any of them. When I mean no contact, I mean no contact at all. Phone calls, text messages, emails, social media, use of third parties, you violate this condition, I will put you in jail. There will be no more PR bonds for you. Do you understand?
Your Honor, it's 2023, so it's complainant and 22 other individuals.
Is there a duplicate filing in this case? Do you mind? I'm showing that there are two. One was filed 6/2, one was filed 6/3. One is in warrant status. Looks like he may have. So it is the true.
Judge, it says it's a refile. Information for the case number ending in 322. It says it's a refile. Okay. I will dismiss the refile, Judge. Okay.
Okay.
I think one was a 2B, and then I really just filed it.
Got it. Okay. Mr. Johnson, do you have the ability to hire a lawyer? Okay. I need to know everything about you to see whether you qualify for a court-appointed lawyer, what kind of cars you have, how much money you have in the bank, stocks, bonds, mutual funds, IRAs. I'll take a look to see whether you qualify. You need to be at the federal poverty guideline to be able to qualify for a court-appointed lawyer. You can fill out an application and Deputy Williams will give you an application. We're going to have bond conditions created for you to sign. The other condition that you have is you are not to be in possession of any kind of weapons whatsoever while this case is open. For now, I'm going to have you sign a reset. We'll have you take your seat in the jury box. So we'll get your bond conditions and then we'll have you fill out the application, sir. Please.
And that's no contact with any of the complainants.
Right. And no other, right? Yeah. Mr. Gibson Tanner.
Yes, Your Honor, I'm here.
Morning, sir.
Morning. I'm here on Davis Wheatfall.
Wheatball?
Yes, sir. Davis-Wheatfall.
Oh, David. Got it.
You need a cause number?
No, let me see. Well, I didn't see that. Okay, I see it now. Do you just want to reset?
Yes, sir. I spoke with the state on Monday when I was in your courtroom, and there's still discovery outstanding. They're still trying to get the discovery from, I guess it's HISD. So yeah, I just need to reset.
Out July 15, 16?
Hold on a second. You said July 15th or 16th?
Yes.
Yeah.
Can you give me 1 second? Let me check my calendar. We can do July 16th.
Okay.
Okay. All right, we'll see you then.
All right, thank you, Your Honor.
Have fun.
Bye-bye.
Good morning, Mr. Tyser.
Good morning, Your Honor.
What's up?
Here on Toy Tanner, she was to pay some restitution and cases would have been dismissed. However, Ms. Tanner had an automatic withdrawal that she didn't account for come out of her account and thus didn't have the money. She is able to pay it by this Friday. I'm just going to have her send it to me and I'll pick up a cashier's check and pay the restitution. If you could give us till, let's say Monday by.
I'll give you till Friday, man. I mean, this has been over and over and over. We're at 225 days now, you know?
Right. Well, okay. Yeah, Your Honor, I know you don't remember, you hear tons of.
Really, it's always something though.
Well, but we just got the restitution amount, I think, at the last setting on this case.
When did you guys offer the restitution dismissal?
He said we shared the bill on May 28th. So we had a referral with court. Then he hadn't sent us any.
I can't hear, Your Honor.
He's saying that she gave you the restitution information on the 28th of last month.
Right. It was at the last setting?
And it's been now nearly 2 weeks. Tomorrow will be week 2.
Right. Your Honor, we believe this, and this is why she didn't pay it was because, well, why she wasn't able to pay it was because she had the automatic withdrawal that she didn't account for.
Okay,
And
so you're saying Friday it'll get paid though?
yes, sir.
Great. So is she here now?
She is. She should be in the audience, Your Honor.
Okay. If it's not paid Friday, then I'm going to roll her day for day.
Okay. All right. I'll explain that to her, and I think we'll have it paid. I'm pretty.
Come on up, ma'am. You need to have it paid by Friday. You understand?
Absolutely.
Okay. All right. We'll have you sign a receipt and we'll get you out of here, ma'am. Please. Yes, ma'am.
All right.
All right. Thanks, Sean.
Thanks, Your Honor. May I be excused?
Yes, sir. Take
Thank
care.
you. Thank you. Bye.
Hi.
Good morning, Your
Good
Honor.
morning.
I have a plea today for an in custody.
Okay.
Doing this,
You getting him? Okay. Got it. Good morning, Mr. Goodman. Sir, you're charged with criminal trespass. You're also charged with prostitution, second offense. You're facing up to 6 months in jail on each of those cases. Looks like you've worked out an agreement where they're going to dismiss the prostitution in exchange for your plea on the trespass. You need to understand that the prostitution case is an enhanceable offense. If you keep picking those up, at some point you will be hit with a felony offense. Years instead of days. You understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This will go on your record. It will be there forever. From now on, you're facing a minimum of 90 days in jail. You understand? How do you plead to the offense of criminal trespass? I'm going to find you guilty. I will follow this agreement, sentence you to 30 days in jail, give you credit for the 11 days that you've done. Good luck to you, sir.
Fugitive hearing time. Louisiana wants this guy for cyberstalking. The defense argues, but he has a lifetime protective order telling him to stay away from Louisiana. So one court says stay away, another wants him back. Legally, extradition only requires valid paperwork, not fairness. The judge's call? You're going back. Argue it there. That's cold, but it's correct law. Question: should a conflicting court order block extradition? Yes or no? Drop it.
All right. It is June 10th, 2026. We are here in cause number 2610376, State of Texas versus Luke Therio. We are here because Mr. Therio is wanted out of Calcasieu Parish, Louisiana. There is a fugitive warrant that was issued back in 2022, if I'm not mistaken. Guys, would you announce yourselves for purposes of the record, please?
Dave Kim for state. Haley Alfaro for defendant.
The reason we are here is for purposes of the record. It appears that in Mr. Therio's case, he was picked up mid-March, went before a magistrate March 16th of 2026. And at that time, he had the ability to either waive extradition or refuse extradition. And it's apparent here that he at that time refused extradition. For purposes of the record, also, he's wanted for cyber stalking, violation of constitutional rights, among other things. A governor's warrant has been obtained in this case. It also appears that an application for writ of habeas corpus was filed yesterday, 6/9 of 2026.
Yes,
State,
Your
would you
Honor.
like to proceed?
At this time, I'd like to introduce the governor's warrant. A copy has been tendered out to council, along with an order securing fugitive after service of a governor's warrant.
Okay. So it looks like you have obtained the governor's warrant.
Yes, Your Honor. And state is waiving notice requirements for the writ of habeas corpus. State is ready to stand opposed to the writ.
Okay.
So for the governor's warrant, he is wanted out of Calcasieu Parish for 2 charges: false statement concerning denial of constitutional rights under warrant number LCPD 2024-010163, and cyber stalking under LCPD 2022-005784. The data incidents were October 25th, 2022 and June 10th, 2022, respectively. And the warrant was signed on November 9th, 2022 and November 1st, 2022. In the defendant's application for the writ of habeas corpus, it only alleges 1 violation, that the papers are not in order, and only cites 1 affidavit where it states that the date is inconsistent with when the warrant was signed in 2022, because the affidavit notes that it was from August 2024. However, that discrepancy is actually a lexical ambiguity. The second warrant for the false statement concerning denial of constitutional rights, while the warrant was signed by the 14th District Court in Louisiana, it wasn't entered into NCIC until August 2024. And so it is not incorrect. It was just addressing a different part of the warrant process. For the governor's warrant, it has shown to fulfill all the other requirements. And under Coester 450 Southwest 3D 908 is that once the governor's warrant regular on its face is introduced into evidence, the burden shifts to the accused to show the warrant was not illegally issued, was not based on proper authority, or contains inaccurate recitals. However, they may not complain about any of the papers which have not been offered. This stems from when he was originally arrested in March 16th, 2026. A governor's warrant was issued out, or a petition was issued out from the state of Louisiana's DA's office on March 20, 2026. The sworn statement from Detective Russell in Louisiana was signed on April 1st, 2026. It was sent to the state of Louisiana Department of Justice, to the Attorney General, Liz Murrell, and a governor's warrant packet was requested for the Louisiana governor, Jeff Landry. The Louisiana governor signed the governor's warrant on May 4th, 2026, and remitted it over to the Texas governor's office on May 27th, 2026, where our governor, Greg Abbott, has signed and accepted the governor's warrant. It is issued out from our Secretary of State, Nancy Nelson, to our sheriff's office on May 29th, 2026. And the defendant was served yesterday, which has been provided to a copy of this court on June 9th, 2026. And so otherwise, the papers are in good order, and the state has fulfilled their requirements under codified 5113, that is met the Uniform Act for extradition.
Do you have any issues with the paperwork?
Yes, Judge, we do. And this is not outlined in the actual application for the writ of habeas, but there is one other issue regarding fugitive status. But I'll get into that one. The issue here, the main issue was the fact that the documents on their face are not in order. We have an actual affidavit from the detective that was involved in this case, saying that these actions were done on August 2024. Mr. Theriot has been living in Houston, Harris County, since May of 2016. He was actually served with a restraining order, a criminal order of protection, and it actually includes that it's set for its permanent lifetime. He was actually ordered to remain in Katy, Texas with his father. This is an order that was brought down by the same parish that is now requesting that he come back, even though there's an order contradicting this because they had previously been told, he had previously been told to stay away. He has a permanent lifetime order in place in case number 7543-16 out of the 14th.
So you're saying there was a lifetime protective order? That was it?
Judge.
Okay.
Yes, and this was signed on January, this was filed on January 12th of 2017. All these incidents, even if we were to agree that all of them occurred on March, June, and October of 2022, and I'm aware that there's a carve-out exception under Section 6 of the Uniform Extradition Act that accounts for cyber-stalking crimes or crimes that can be remotely committed, right?
Right. I mean, that's.
Right, and I understand that part, but I also understand that he has been given two contradicting orders. One order restricts him from going near that property and from stay and to stay here. This is a permanent lifetime order, and as far as I know, it has not been revoked, it has not been overturned. No other judge has said, yeah, he can freely come back to Calcasieu Parish. So Mr. Theriot has been complying with that order since about 2016. And such, he's not willing to return back voluntarily to the state of Louisiana in direct violation of this order as well. Yes. I don't know.
But does that have any issue with, on its face, and the fact that the extradition documents are not in order?
Well, the main contention as far as the documents not being in order are the fact that there's a discrepancy in like a 2-year gap date, where the individual involved in this case has one previous affidavit that they used to secure a warrant that says that these acts happened on October 25th of 2022, whereas the new affidavit that was signed by that same individual on April 1st of 2026, he's alleging that these acts happened in 2024. That's a full 2-year discrepancy. If it were like a matter of days, I understand the leeway that is given with the honor about language, but I think that.
Sure, but I think that that's something that's handled over there.
As the court knows, for 5113 for the receiving state is that they are required to have 2 affidavits with warrant statements. The first one the council is referring to is the initial arrest warrant that was signed by the 14th District Court.
Sure.
The second one is an affidavit signing and attesting to the governor's warrant. And so that's.
Okay, so. I'm going to grant the governor's request, and I'm going to order you to return back to Calcasieu Parish. You will be held at no bond while this process is going on. I would imagine within the next just couple of days, you'll be back to Calcasieu Parish, and at that point, you can deal with them and issues of bond and whether they'll, grant you another bond. But at this point, we're going to order you to return back. Do you have any questions?
Just the governor's warrant states that I was physically present in Louisiana to commit the acts. Is that mean that they're not on?
I haven't seen.
And that is correct, Judge. I believe an affidavit prepared by Jacob Johnson, part of the governor's order packet, clearly states that Mr. Theriot was physically present in the year of 2022 to commit these offenses, physically present in the state.
I wouldn't know. I don't.
I have a witness who can testify that I was at the house.
So that's something that you'll have to take up when you get back over there. This here, we're only trying to determine, are you the right person that should be charged with this offense? And whether there's enough to send you back to Louisiana to answer those charges. That's what my concern is identity. Are you who they say you are? Are the documents in order? If they are, at that point, we'll send you back and then you answer the charges over there and then you can make those arguments over there.
What about the 4th prong review, the status as a fugitive? That I fled the state and that I'd be entitled to the governor's discretion and not a mandatory.
It's just whether you are a fugitive. That's just the last prong.
We addressed this earlier, is that there's a carve out under Section 6, is that there are exceptions in what we colloquially call 2B warrants, that they are recognized by both governors of Texas and Louisiana as qualifying for 5113.
They do. 2B warrants are issued all the time, Yeah. So, all right.
All right.
So, Your Honor, just for the record, in accepting the governor's warrant, state would like to introduce Exhibit A for the governor's warrant and the service, and is the court formally denying the writ for the defendant?
Yeah. All right. Do you have any objection to the admission?
The admission would be the original governor's order packet that we will
With the
provide.
service slip.
Yeah,
Yeah.
no objection to this.
Okay, it'll be admitted and the writ will be denied.
Can I appeal the denial of the writ?
Sure. Yeah, and she'll go over that with you, but I'm going to grant the writ. I mean, not grant the writ, I'll deny the writ.
You're sure?
Okay,
Thank
thanks.
you.
Maybe the excuse, John.
Yes,
We have the right.
off the record.
Oh, right.
Judge,
Hey, yeah,
I think, right now, the first one is William. William.
okay. It's jail case, right?
No, this is on bond.
Okay,
She's here in the audience, Judge. She is, she's in for a prostitution case. She's completed, kind of the terms of her PTI. It's just, she's got a month left until her discharge date where she doesn't have to go into new case or anything. Right now, she's got an equal monitor on her. We would support it if we could address, if we could take that off.
she's fulfilled everything for the dismissal. She just needs to stay out of trouble.
She's here, Judge, and, for what it's.
I understand. Well, state what's your position. Yeah, okay, I'm down.
Uh,
Number two.
And then my second one is the trial. That one, will be jailed out.
It is on the jail.
This one was a 10-day discovery setting for surveillance.
Oh, right, okay.
The identity of the officer. As of right now, spoke with the chief, we don't have it right now. So.
Judge, we're having our investigator go in person to get the surveillance video.
It's 150 days and he's in jail. So, I mean, I guess I'll give you to the end of docket. He's bond denied and upstairs regardless, but I guess I'll give him to the end of docket. If you don't have it by the end of docket, then okay, all right. Thanks, Sebastian. Hi, please. Hi. Okay,
Hoping to get him into PTI, set for a TRAS on July 1st. So we're hoping to get this case reset sometime shortly thereafter.
is he here now?
He's not here today.
Okay, it's 180 days. I'm not going to wait. You said when is this set?
July 1st, TRAS date.
Let's do this. Pick a day next week, have him come, and then we'll send him to go do a walkthrough to TRAS so we can kind of speed things up a bit since it's already 180 days.
Understood.
I don't care whatever day you want, just have him come. Any day good next week? Yeah, just pick whatever you want. We'll have him come, send him to a walkthrough to TRAS, and after that, we'll give you a couple weeks to finish it up.
Understood. All right.
Yeah.
We'll see you next week. Thank
Yes, sir. Sit top of 34.
Yes, Judge.
Is he here?
Yes, Judge.
Yeah, we need to do PC.
Yes.
Yeah, we need to do PC.
And
Deontay Smart, come up.
I would like to kind of hold off on it so I can look at the discovery a little bit. There's two.
Well, I get it, but I still have to do PC on it. I can't not.
Okay. Now, if I recall, you do allow us to reapproach up to you.
Sure, of course.
Okay.
Yeah, absolutely.
Perfect.
Yeah. Anytime.
I'm signed on the case, but I have not had a chance to do it.
All right, you are Mr. Smart. Sir, you're charged with unlawful carrying of weapon and displaying a fictitious license plate.
The fictitious plate was already to death. He's read to Wednesday. June or July.
July.
Oh, he picked up a new case. Oh,
And that's why
Oh.
PC is a little more interesting.
we are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On June 6, 2026, in Harris County, Texas, officer observed a vehicle traveling with an expired license plate. Our traffic stop was conducted. The defendant was a front right passenger, but also the registered owner of the vehicle and stated he is the owner. Officer observed a strong odor of marijuana from inside the vehicle. Officer observed the front of defendant's shirt to have recognized pieces of marijuana on it. Defendant admitted to smoking marijuana earlier and also admitted to being in possession of a handgun inside the vehicle. Defendant stated everything in the vehicle belonged to him. Officer located inside the vehicle a plastic pouch of marijuana as well as a handgun on the front right floorboard of the vehicle.
As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be tested 40 days from today. If you test positive for dope or alcohol, I will revoke your bond and put you in jail. Do you understand?
Boom. What happens now? You're going to jail today. This defendant picked up a new case while on bond. Fictitious plate, marijuana, handgun in the car. The judge says, I don't ask much. Don't pick up a new case. And then he revokes. That's the reality of bond conditions. They're not optional. Here's your engagement. Should any new arrest while on bond trigger automatic revocation, or should judges have discretion?
The one thing I told you not to do was pick up a new case, and you picked up a new case. What happens now? What happens now? No, you're going to jail today. I don't ask much from you. Don't pick up a new case. And if I find that you have a weapon again, it's just going to keep going higher and higher. You understand? Okay.
He's got, he made a,
I'm not going to touch the new case, but I'm going to revoke it just on the old one,
so I can tell his family what's the.
5001.
For the fictitious plate. We should consider 500. And let me.
State, what do you say?
We defer to you, Judge.
All right, I'll set it at 2501, but I'm going to tell you now, you will get tested 40 days from today. And I'm not going to play this game with you. Do you understand? Okay, all right. Hey, you ready, Janet? Hey, what's up?
Sophia Harris.
Jail or bond?
Harris.
Okay,
So, the DA did make me an offer. The problem was my car was broken into and my briefcase was stolen with all my files and my calendar. I'm an accountant. So I've been
It's okay.
recreating my calendar, but I just haven't been able to sit down and like talk to her about it.
so you're at
So it's just a
172.
reset.
We'll give you one last one. She's got to be at the next setting.
Okay,
Discovery complete, and is there an offer on the case?
there's a very nice offer.
Okay, so that's it.
Okay.
This is the last reset, okay?
Okay.
All right,
Thank
yes,
you.
ma'am. Stace,
All right.
is he here?
Not anymore.
He left? Okay,
He realized he had to give me our, he walked out.
I'll give him to the end of docket in the event that he shows up. We'll call his name at the end 3 times. If he's not here, at that point, I'll revoke the bond. I'll grant your motion. Just, I'll reach out to you if he shows up, but I'll give him the benefit of the doubt until the end of docket.
Okay.
Okay, thanks.
Answer, you know, I have any doings.
Okay, let me give it to you, or do you got it, Dustin?
It's 262-3545.
2623545. My only concern are, because it's a harassment case, are there any conditions that we should place? Do you mind, I guess, reading what
The
happened?
protocol is actually, I'd like you to look at that and see.
Sure, of course.
Present, but it's.
I know, yeah, but it's okay.
Harassment statute.
Law enforcement were dispatched to a public roadway in reference to a vehicle disturbance. Complainant advised defendant followed her to her residence and threatened her following a road rage incident. She advised she was stopped in the intersection at a red light. Defendant honked immediately when the light turned green. Complainant advised she made a left turn onto the bender. Defendant was behind her and made a left turn. Defendant attempted to go around her, but was unsuccessful due to traffic. She advised defendant followed her to her apartment complex. Defendant appeared to reach into his backseat for something, took photos of complainant with his phone. Defendant circled the parking lot yelling, "I know where you live, I'll be back later." Then yelled racial slurs. Complainant feared for her safety and believed defendant would return. Complainant followed defendant to Planet 4 to get a better description of his license plate. Provided license plate to dispatch. They initiated a traffic stop on the defendant's vehicle for failure to signal lane change. He advised he was in a road rage incident where complainant brake checked him several times. after he Ubered the horn at her. Defendant advised complainant followed him to Planet 4, denied following her to the apartment complex. Defendant advised he wasn't going to harm her, he just blocked her on social media. Complainant provided recording of the interaction, which shows defendant circling the parking lot of the apartment complex, yelling, SU cracker. The light just turned green. Defendant responded, I know where you park now. I'll be back later. I'll be back later. You better watch yourself. And yelling racial slurs will drive off.
General argument, the racial slur is this white guy called the other person a cracker likely.
Well, let's pull the statute.
Planet 4 is literally right next to the apartment complex. My father's driving it. So he took a picture of her plate. She followed her, took a picture of his plate. That don't seem harassment. I mean, it's just being stupid. It's what we see on the news all day long. I think it's
Whoa.
Grizzlies, good news and stuff.
But so harassment occurs when an individual with the intent to harass, annoy, alarm, abuse, torment, or embarrass another engages in specific prohibited communications.
So they're not prohibited communications. It's not, I mean, it doesn't track as military.
Well,
What you're telling me is every person that might have this courtroom, including the DA's office, would be in jail today for harassment based on.
I think that I would perhaps agree with you, but for the fact that they're saying it goes to the actual house.
The house is 5 minutes from where he went because he was getting a vehicle service, dropping a vehicle service. And it's clear. I know you don't know that. I mean, that'll be a trial down the road when it gets there, but I mean, I don't.
Yeah, I think that, so I think that there's enough for probable cause purposes. The only thing I'm going to order now, and what I can do is I can give you the conditions,
Okay.
have him sign it, get it back to us by tomorrow,
It's,
and then we'll set it for next week, whatever day you want. But in the interim, he needs to know that he's not to have communication with her, no weapons, no going to her house. If you can file those, I'll print it out. I'll give it to you. I'm going to find PC, but pick a day, whatever, next week. He'll come. We'll just have him sign everything and then but yeah. So pick whatever day you want next week. Just before you leave, let us give you the conditions. He's got to have it signed back to us tomorrow.
Yes, sir.
And you can just file it,
Will he file
sure.
it? Oh, I did it.
Okay.
Just to make sure, no contact with the complainant, no returning to her address, no firearms.
Right. No going to her work, place of, where she lives, just no contact whatsoever.
Yes,
Yeah.
Thank you, sir.
Okay, Dustin. Thanks, man. So he still has the case upstairs going on, right?
He plans this case up.
Oh, really? Wow. He just got filed.
Yeah.
Right.
Yeah, probation.
Wow. That was quick.
Mhm.
All right, Mr. Wessels, good morning, sir. Sir, you're charged with driving while intoxicated, second offense. You're also charged with possession of a dangerous drug. On both of those, you're facing up to a year in jail and or a $4,000 fine. It looks like you have worked out an agreement where they're offering you 9 days in jail with credit for the 3 days that you've done. It looks like it's a reduction to a first. You know how many people we have in TDC doing life on a DWI? This is now 2 with us, a second, and now you have a DWI upstairs. What's it going to take for you to get the message? Serious prison time? You and all your 100-pound, you know what they would do to you in our Texas prison? You have any clue what they would do to you in prison, Mr. Wessels? Take a guess.
Whoa, intense. Judge Fleischer just said, I've read stuff about Texas prisons that had me in tears. He's warning a repeat DWI offender. Next time, years, not days. And then the practical advice. Take an Uber. Always $30. That's savage but true. Legal takeaway, DWIs escalate fast. Third offense is a felony. So here's my question. Should repeat DWIs have mandatory minimum prison time?
I've read stuff and it had me in tears because of the way that some people treat it in our Texas prisons. It's freaking disgusting. You are now facing up to 10 years in prison. If you have a problem with drugs or alcohol, it's probably a good time for you to address it because really, the agreement that you've worked out is 9 days in jail, credit for the 3 days that you've done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you are not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. You understand? Every time you pick up a DWI now, you will be facing serious prison time. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement, sentence you to it. I'm going to suspend your license for 1 year. Do not drive until you get a license. Stop getting into a car. Don't drive. You and cars do not mix well. Do you understand? If you want to get lit, take an Uber. $30. It's a geographical oddity. Wherever you want to go in this life, you take an Uber, always $30. Good luck, sir. Thanks. Dan,
Yes, Judge.
you ready?
Yeah, I have Frank Garabee,
Okay.
2 cases. We submitted the PTI packet. Tried to call him for his insurance. He didn't answer.
I guess we lost. Let me see how, thanks.
We're working on applications and.
So he says he's submitted this. Do you have the on Garabay?
Gary?
Yeah, with the G.
We have not.
You filed it today, Dan?
No, I think it was filed, my secretary did at least a week ago.
Who did you send it to? Did you send it to Kenneth?
I'll send it again, Judge. To
Okay,
Kenneth?
do me a favor.
Yeah,
Will you CC Farwa or DA here? I will send you her email. Just bear with me a second. I don't know if you have it.
You can have me for the Serenity is out today.
Say it again.
Serenity is out. It's a CC me on the email instead.
Okay. I'm going to send you her email if you don't mind CCing her
okay.
so that we know. Bear with me a second. That's it.
Okay, let me write it down.
And then we'll set you off for a couple days, for any day next week
Okay,
to see whether it's accepted or rejected. If it's accepted, have him come here so we can send him to do a walkthrough TRAS. If not, then we got to figure out what we're going to do. Pick a day next week. I don't care.
next Wednesday.
Okay.
Okay. The next person?
Fabella is the next one.
Yeah, we're just waiting on the contract.
Fabella with an F.
FEBELA.
The contract was sent, yes, the contract was sent to defense on June 8th.
On when?
June 8th, 2 days ago.
2 days ago, they sent it to you. Do you have it?
Okay. I'll look and can we set it for next, can I get so I
I'll
can
give you
get
2 weeks on that, Dan.
Yeah. Okay, sounds good.
So hold on, let me get your date. No, page 8, bottom. They just got the contract 2 days ago, so you're going to give them 2 weeks.
Bottom of 8, is that 2 weeks?
Yeah, they got the contract, so they have to finish up everything.
June 30 through July 2nd.
July 2nd.
July 2nd.
Okay.
Okay, then next is Garabay on page.
No, that's the one we submitted the packet, submitted the PTI. But I'm going to resend it. Is set for next Wednesday, Garabay?
Next Wednesday.
Wednesday, Judge, that's a FIFA date.
Okay, pick any day but Wednesday. It's a FIFA day.
Oh, okay. So what about that
Friday,
Thursday?
go to. So
Thursday?
no Wednesday, no Friday, because Friday we're off.
Okay. Then the next Thursday.
Thursday. Okay.
Okay, and then the last one is Frank Garabee. We tried to get him a PTI, but he was denied.
You mean Rodriguez?
I'm sorry, Rodriguez, Your Honor. Alfredo Rodriguez. We tried for a PTI, but he was denied. So I just waiting on a different offer from the state.
He has a probation offer on the portal.
It's 276 days old, Dan, so.
Okay, can we set it for next? Yeah, can we set it for next Wednesday, Judge? And we can
Sure.
finish it.
Okay.
Okay. I mean, next Thursday.
Thursday. All right.
All right,
He's going
thank
to be
you, Your
here
Honor.
next Thursday to take care of it or get set for trial.
Sounds good. All
Okay.
right, have a great day.
You too.
Bye-bye.
Have fun. Hi, Herm. What's up? Yeah.
No, purchase vehicle, sign them up.
Sendable?
Yes, yes. It's not that old, but he has a request to transfer the scram for the interlock now that he has the vehicle. He'd like to drive.
Yeah, I'm not going to take it off, but if he wants to drive, I'm okay with it. And we'll have him have an interlock. But he just had a BVR not less than a month ago, so I'm not going to take
Is that
this.
agency paid as well? Or
Sure.
Okay,
Of course.
okay,
Yeah.
I'll wait for your J-Lo then. Thanks.
Yeah.
Victoria, do you have a J-Lo today?
How are you, Judge?
Hi, what's up?
Your Honor, I have Mr. Portland Roberts hyphen Clay on the docket. He's got two cases. The older case is a motion to adjudicate an assault family member. The newer case is a new law violation of harassment. I visited with the prosecution about Mr. Roberts' Clay cases and we discussed some outcomes. What I've requested of the prosecution as a potential alternative is that, should the court allow, of course, that we extend Mr. Roberts Clay's deferred from 13 months, which was the original term. And he's pretty much, that term actually, I think, expired at the beginning of this month or late last month. And so extend it to a 2-year probation and keep him on probation and alter the conditions of probation from no threatening or harassing to straight no contact. The complainant in both the assault family member and the harassment case is his child's mother. So normally there is inherently some communication. I've informed my client and the state that I'd be asking the court, should the court go along with this, of course, to order that there be any child care communication go through a third party intermediary to comply with the no contact provision.
Have we done a TRAS yet?
No, sir.
What I'd like to do is set it for a TRAS to see what they recommend first.
Okay.
With all these assaultive cases, I don't even know. And now we have a new assault and another harassment. I think
It's just a harassment, Judge.
I'm sorry, right. Well, the fact he's on deferred.
No, understood.
So what I'd like to do is easy here now.
Yes, Your Honor.
Let's send it for a TRAS and then we'll set it off 2 weeks to figure out what to do. But I don't want to. Let's set it the last week of June to the first week of July, and then we can try to pursue an outcome. But I'd like to know what they recommend to see with this kind of history. I don't know. I don't know. Don't want to agree because I don't know how to go forward. What kind of. So let's send them today, and then we'll just give you a reset.
Are you good with everything that I represented?
Yeah. Okay. Sure. All right.
Thank you.
So just reset it to like the last week or first week of July. We're going to send it for a TRAS now and see what the results say.
Thank you.
Appreciate that. Hey, come on up. You ready? Yeah.
I'm coaching on pace.
Okay.
PACE.
Yes. What are we doing?
As far as the bond conditions go, she has an 8-month on. Just want to ask the court, would you be willing to just amend that? She's in nursing school. She's.
Is that Miss Pace there?
Yes.
Her case is 500 days old on one, 524 on the other, and then 29 on the third. I'm not taking it off. Sorry. It's just, she's been gone way too many times. It's just not going to happen. And we need to figure out where we're going because these cases are super old.
Yes, Judge. So I just got a point at the last setting, still going through all the discovery, the 3 cases.
Got it. Yeah.
I probably just need one more setting.
Sure. Of course. Yeah, absolutely. But I'm not taking it off. It's not going to happen. Sorry. Yep. And counsel, let her know if she ever takes off again, I'm going to go bananas on the bond.
Judge, how much time on that one?
Just normal setting. On pace. Yeah, she's got the new case and it's only 29 days old. Withdrawal. What's up with Hernandez?
Judge, we previously represented the complaining witness.
Where is the defendant now?
He is not here, Judge.
I can't grant it until he's here because I don't want to let him go without counsel. So let's do this. Have you had contact with him?
I'm not able to report any contact.
When is the last time you reached out to him? When is he set for now? Let's see. He's set for 6:25. Why don't we do this? You want to set him for Friday? And then
6:25 workday, Judge. Just because he made aware of it.
are you sure? I know that is he,
Like I said, I'm not able to report anything else.
let me see. Is that? Okay, that's a required setting. Let's do this. I don't want to rule on it until he knows about it, and chances are like if what I'm hearing is correct, you're having a hard time getting a hold of him. So I don't want to do anything until he knows about it because I've had people I've granted motions before. A defendant gets here and goes, I can't believe my lawyer withdrawal. No one told me. So I'm happy if you want to put it on earlier and I can rule on your motion and that way I can appoint him on another lawyer simultaneously. But I don't want him to be out there thinking he's got a lawyer when he doesn't,
Yeah.
Right. So if you want to keep it on 6:25, we can keep it on that and I'll rule it on that day. Or if you want to bring it closer Friday or next week or the week after, then.
Yes, I'll keep the current date.
Okay. All right.
Yes.
Thanks. Hector.
Judge,
Hey, good morning. What's up?
Judge, I'm going to 2 cases for Carlos. I think they are having a bad morning today.
Who's first?
The first defendant is David Renee Granados.
Granados.
Okay, top of 16. Yeah.
Thanks. Okay, where's Mr. Granados?
Judge, she is here.
Okay.
In that case, I spoke to the prosecutor this morning. She wants to put her final offers on that case.
It's
The defendant wanted to speak to Carlos. Carlos is not going to be able to make it here till later. So I didn't know whether or not you'd want to carry it for a couple of days, maybe until Monday, just so
sure,
he can talk.
but at that time, it's time.
Yeah, Judge.
Yeah. Okay,
It's-
Monday's cool.
I've already
Sure.
forwarded those offers to their office and I want Mr. Granados to feel comfortable with everything.
Yeah. I understand. Sure.
Judge, the second case is Nelson Cruz Rosas. And Judge, on that one, he's been approved for VWI PTI.
Is he,
I don't believe he's here today. No, yeah, I don't believe he's here today, Judge.
is it under Rosas? I don't,
Yes, Judge. Page 31.
Oh,
It's-
he is here, Judge.
okay, it's 222 days old.
He just needs to sign his VWI contract and get the interlock box, Judge.
Okay.
So again, I just was looking for 2 weeks for him to be able to.
Come up, sir. 2 weeks, I'll give you a week. It's 222 days. We have literally,
If he's gonna be able to get the interlock back fast. That's the only reason I was asking for that extra time. If they get it done before, they can come before the meeting.
do you speak English, sir?
No, he's fine.
Tu caso ya tiene 222 días. Está extremadamente viejo. Tú tienes 2 semanas para terminar todo o te traigo cada día hasta que lo tienes hecho. ¿Me entiendes, Méndez? 2 semanas nada más. Okay.
Thank you, Judge.
All right.
So for those
2 weeks, yes. Judge, on the PTI, my understanding, I've already got the interlock. So I'm gonna talk to Mr. Rodriguez's office and get them to do it ASAP, so we get it going.
So we'll do next week then. Same thing, Monday?
They reset it, but I'm gonna have to try and start by Friday this week.
Well, but then I don't want to do 2 weeks if he's got everything done. There's no sense in setting it another 2 weeks if it's 225 days old. So, I mean, just pick a day next week
That's fine.
for homeboy.
Judge, can we approach?
Of course.
Hey, Judge. This is an off docket matter. We were here last week. You said to come back and approach off docket. This is on case number 260.
Oh, hold on. Let me.
Sure.
260
Yes, 5977.
on Smith.
Yes, and I just looked around and we don't have a pretrial services officer, so I don't know how useful this approach will be, but we discussed removing the GPS monitor device when Mr. Smith was here in court last week. You said to come back and approach, you wanted the state to have some time to speak to the CW, confirm that she was okay with the removal of the GPS.
Yes, Your Honor, I did contact her and she's okay with the removal.
Okay. Have there been any issues? Did you ask?
Nope, he's been on bond since 214. He's been having the GPS monitor device and no bond violations, no issues.
Did you ask her if there have been any issues?
Not asked her specifically, if there's been issues and students want to see if you get paid.
Okay.
I can reach back out.
I would, from now on, anytime you have in a case where there's assault, I would at a minimum say, hey, how are things going? You want the GPS removed? How have things been? Have you had any more issues? If there's no contact, ask them, hey, has there been any attempted contact? I would always ask the full gambit.
I apologize. It was just a quick call.
That's all right. But okay, I'll acquiesce. Just hopefully there are no more issues.
Okay, understood. So removal of GPS monitoring device.
Yeah.
Since we're relaxing the conditions, he doesn't need a sign, right?
Is he here?
He's not here.
Yeah, I'll waive the signature. Yeah,
Right.
not a problem.
This is on-
Hey, Your Honor.
Hi. Yes, of course.
Have Cantu on the docket.
Good morning.
Good morning. How are you? Right.
Good,
Here,
great,
located,
wonderful.
Judge. It's
Yeah.
nice to you yesterday.
Cantu.
Yes, sir.
Jail or bond?
He's in custody.
Okay.
Excuse me. So I just spoke with Karina. We just agreed to a PTI. It would resolve both cases. He has a bond set on both cases, I believe at 252. So it is a low bond, Your Honor, but he cannot afford to post any amount. He's been in custody since April.
Can you bring out Mr. Cantu,
7.
please?
He's been in custody since April 27th. I'm requesting that you to reinstate his original GOV bond so that he can get out bond and complete the classes and we'll get his case resolved.
What do we put him in jail for? Do you remember?
It was,
You test positive or something?
no, it was 7 skips.
Yeah.
7 skips. And we were trying to explain the water was spilled on the device and he was trying to get up with the pre-trial.
So I'm going to put a scram on him.
Can we do agency pay trial? I don't think we can afford.
Don't I do agency pay on everything?
Sorry?
Don't I do agency pay on everything?
Oh. Just like to be sure, you shook your head no for a second.
Get your sister. How's jail? The funny thing is your bond on each of your cases is $252. It would take all probably $50 to get your butt out of jail, and not even $50.
Listen to this. Your bond is $252. It would take $50 to get you out. No one posted it. 7 skips. 7 failures. And the judge still gives another chance, but with a monitor and weekly tests. That's not soft. That's strategic. Jail doesn't fix addiction. Accountability might. Final question. How many chances should a defendant get before jail is the only answer. Comment below.
No one is out there to post $50 to $70 to get you out. So when you are out there in the free world, you should be thinking, if I'm up to shenanigans, ain't no one gonna bond me out. The only time you get out is if we give you a free damn bond. Mr. Cantu. Your lawyer is asking for me to reinstate your bond back so that you can get out. Alcohol was a factor in this case, correct?
You'll look right now, around. Yes, Your Honor, it looks like the defendant did have, was holding, 2 alcohol beverages.
So the only way is if we put an ankle monitor on him so we know he's not consuming alcohol. But let me be frank, Mr. Kent, that if you ever violate a condition again, I will never play this game with you again. I'm not going to do this again. You hold the keys to that jail cell. The only thing I'm asking you to do, don't pick up any new cases. Don't endanger my streets and don't use alcohol or illegal drugs. You have been in jail now for how long?
Since April 2017.
You will be negative if I test you for weed right now. If I test you and you test positive for marijuana, that means you have used in the free world. And guess what happens? I'm not going to do this again. You will get tested once a week, so I know that you're not using. So I don't have a pretrial service officer now. So what we'll do is I'll reinstate the bonds now, but he's got to come back tomorrow so that or Friday, so we can do conditions. Okay?
Okay.
You will get a device. You're going to get drug and alcohol tested on Friday. You know it's going to happen. So if you go out there and you consume alcohol, you consume illegal drugs, and you test positive, it's not going to go well. You understand? Okay? All right, I'm with you. But this is it. I'm not going to do this again. Okay.
Maybe
Yes, ma'am. Have fun, man. Martin.
Good morning, Judge. I'm here for Mr. Andrade. He's on jail docket.
Okay.
Judge, he has some pending felonies, and he's hired attorney Mac Miller for those. He's also supposed to be on the misdemeanor case.
He hired who?
Mac Miller. And Judge,
I don't see that Mac's on the case.
Yeah, he hasn't filed in yet. I did talk to him yesterday. Judge, he's having some pretty serious family health issues. I don't really want to speak about it, over Zoom, Judge. It is pretty serious. I think that's the reason why he hasn't filed into the case. I did just text him again right now to remind him. I did speak to him yesterday. He was supposed to file on yesterday, but it just hasn't happened yet, sir. And I'm sorry I left before I addressed
Don't
this
worry
case.
about it. Hey, do you want me to just put it on for maybe next week or something?
Yeah, I think that would be best, Judge, because he's still, he hasn't posted the bonds for his cases upstairs, so I don't think and I think he has a bond on our case anyway, so that would be great if we could do it probably for like next Tuesday.
Tuesday, yeah. All right, we'll put it on for the Tuesday then.
Thank you, Judge.
Okay,
Can I be excused?
got it.
Thank
Yes,
you.
sir.
Bye-bye.
Thanks. Oh, yeah. You were hiding. Hey, what's up?
You couldn't see me from the screen.
Yeah.
I'm
Hi.
approaching on Raul Hernandez,
Jail or bond?
the jail.
Okay, what's the word, Thunderbird?
Bond is set at 10,000, and I'm approaching to see if he would lower it. He can only afford about 2,500.
Let's see. I need to bring him out so we can talk. I've got his,
Oh, that was quick.
What happened?
No, we were saying that we
Can we-
need Spanish interpreter
can
right
we-
here.
when you're, just,
No rush.
he's in jail, we got to bring him out, but we got to put him back first, so 2 minutes.
Do you want me to step aside?
No, no one else is here. Good morning, Mr. Hernandez. You were charged with assault of a family member. You're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay, please.
On June sixth, 2026, officer was dispatched to a family disturbance call at an apartment complex in Harris County, Texas. Officer made contact with defendant and complainant. The defendant informed officer that nothing happened. Officer learned from complainant that defendant had assaulted her. Defendant was then detained. The complainant stated she is defendant's wife, and they have known each other for 4 years and have been married for 3. On June 6th, defendant kept yelling it was her fault he went to jail and punched her in the chest with a closed fist really hard. Complainant's pain was an 8 out of 10. Defendant was arrested previously for assaulting her, and complainant provided an audio recording of the situation. Complainant said defendant has been hurting her for over 2 years. Every time he is drunk, around 1 to 2 times per month.
That he's what? He's drunk 1 to 2 times a month?
Every time he's drunk, he hits her 1 to 2 times per month.
Every time he's drunk, he hits her 1 to 2 times per month. What on earth does that mean? Does he drink 1 to 2 times a month? Does he? Okay,
Can you look at the DIMS to see what the
it's fine.
exact language is, Your Honor?
Is he a flight risk?
Oh, I believe. So straight from the DIMS, Your Honor, so it states, complainant stated defendant hits her every time he is drunk. And then separately stated that defendant hits her around 1 to 2 times every.
Okay.
Complainant.
This is the most serious moment in the entire video. The complainant says, every time he's drunk, he hits me 1 to 2 times per month. And I believe he will kill my son. And the defendant? He says he's leaving for El Salvador. The judge's response, I want his passport first. I'm not in the business of trusting people. He reduces bond but demands surrender of the passport. That's Flight Risk Management 101. Final question for you. Should judges automatically hold passports in all domestic violence cases involving non-citizen defendants? Comment below.
Also initially declined a protective order because the defendant told her he was leaving for El Salvador, but then changed her mind because.
He said he's going to El Salvador?
Yes. And then she changed her mind because she believes defendant will kill her or himself.
Judge, he has an apartment here. He works, he does AC, like, AC repair. Just because he says he's a flight risk, doesn't necessarily mean that he is. We can put proper bond conditions in place, and we're inquiring, we can put him on house arrest.
Well, I would first be, want a passport at a minimum. I would give you a bond reduction, but I'm going to require a passport first, so I know that he doesn't take flight.
He has an American passport, Judge.
Yeah, I'm going to want it first.
El juez dice que si lo van a dar, que lo van a dar condiciones de para que le entregues tu pasaporte.
How would you want to do that logistically? Because I'm not taking custody of no.
No, once you could have someone bring it to here and we'll tender it into a registry here. I'll make a document notation that we have it. Once the case has been settled, at that point, we'll give it back to you and to give it back to him. But I'm, there's no alcohol. I'm going to put a monitor on him so I know that he's not using. no contact. This is a second assault against the same complaining witness. No contact, no going to where she lives, works. But first, I want the passport. So I know that he's not going to take flight.
Okay.
Alguna persona que me pueda tirar, se puede venir a la corte de llegar a pasaporte.
Necesito contactar por teléfono a un sobrino.
Él tiene acceso a tus documentos.
Sobrino, él no conoce, sino
The problem, Judge, is that the apartment that this incident allegedly happened.
He has significant, I mean, I wouldn't say significant, but he has quite a bit of recent criminal history, violent. All right, he has a prior DWI third from a year ago, you know, so I will, but I want to know that he's not going to take flight. And the way that I know that is
I'm just,
taking his passport.
I hear where you're coming from. I'm thinking about from a practical perspective, how are we
That's-
going to get into that apartment and get his passport? Considering that.
That's not, I understand, but he's already threatened to leave and go back to El Salvador, from which he's a citizen from. So, well, I'll let you guys work that out. I will give you a bond reduction. Are you okay with it?
Don't be approached upon reduction as long as.
If you find somebody to go back to that apartment, considering that you told him no contact, technically that would be a third party contact. Can somebody go to the apartment, his apartment, with his permission, go into the apartment and get?
Well, that's up to him. That's up to him. Don't have any issues. I don't have any issues with that. He cannot have contact with the complaining
Correct.
witness.
Correct.
So he cannot relay any information to a third party to try to give information to her.
Okay.
So okay, well, tell her this, tell her that, no, just get the passport
Okay.
and I'm okay with
I
that.
can hear everyone talking.
Okay.
So, well, yeah, I'll let you guys,
Sheriff's
Okay,
property.
so he,
He says it's in the property.
oh, okay, there's a white card that you can fill out to try to get it.
yeah, I don't want to take custody of his passport, Judge. I've taken custody of property of clients and I had to hold on for years to them and be responsible for it. I'm never doing it. Especially on a US file or any kind of documentation. Okay, let's figure out a way to get it. But I'm not taking.
He can, that's okay. So he can do a power of attorney and give it to someone else, I guess.
Someone, yeah.
And yeah,
I've learned my lesson.
but I understand. Okay. So I guess we don't have anyone to do conditions now. So, hey, Andrew, we don't have anyone free trial here to do conditions now.
Okay.
Oh, wonderful.
Hey, Judge.
Hi.
Let's
see what let me see what the match did.
Judge, if the passport is in custody of, like in his belongings when he got booked in. Okay, would you be willing to set a bond? Just hear me out,
Okay.
Set a bond and give him 24 hours to turn over the passport, which means he comes out and if he gets released during 4 hours, he comes straight here. If he gets released outside of business hours, he comes in the next day, and if he doesn't show up, you revoke his bond. He's not gonna be able to leave the country with a warrant.
I don't want to take that risk. We're not in the business of trusting people here, you know?
So you're trusting a complaining witness who says something, so you believe what she says.
I'm not believing anything. There's a magistrate has found probable cause. It's a second one. He's got violent history. And he said that he's going to take off to El Salvador.
Well, according to her, so you believe her, but you don't believe him.
Told you I'm willing to give you the bond reduction, but I'm not going to trust. I don't want to.
Thank you, Judge.
Yeah. Estrada, we were waiting on them to get the surveillance and they got it. So, but Sebastian left. Did he reset Estrada with you?
did, Judge.
He did? Oh,
Yeah,
okay.
we said it.
Okay. So yeah, just let him know so that we,
Yeah, I sent it to him. I told him before he left, but that's probably why he just.
okay. Hello?
Thank you.
Sebastian, hey, let me put you on speaker. Hold on. Hey. Sus not ex parte. Are you here?
Yes.
They got the surveillance.
Yes, no, I saw, I talked with, I got the name of the officer.
Yeah, okay. So I guess we'll just keep it on whatever you want. It doesn't matter to me. I don't,
Yeah, I told, I gave Victoria the date.
Okay.
You know, for right after, just in case, but yeah.
all right, man.
Thank you, Judge.
Have fun. Bye.
Bye.
I was his chief when he was in the DA's office, so he should have known better.
Tell when someone's disappointed because, you know,
I did my.
got it.
Mr. Carey, he's made bond now, so I think he needs bond conditions.
Okay. Coming up, sir.
Sure.
Do you want to set it? Do you still want to have the hearing or no? Well, because I have to find, because if he picked up a new case, if I find PC, I'm revoking his bond on the first case.
Sure. I mean,
So
right,
we got to do it.
There's a little less urgency now that he's not in jail, but I'm happy, yes, I do. Because I still think there's no PC.
Then let's do it, because when someone picks up a new case, one of the things we tell you to do is don't pick up a new case. Stop. We will have a hearing. In the interim, you're not to have contact with the complaining witness and not to be in possession of any weapons. Do you understand? So you tell me when you want to do it. I'm here this week and next week. I don't care.
Maybe next Tuesday?
Sure.
Next Tuesday.
Okay, set it. You must be here on that day. We will have a probable cause hearing and then we'll go from there.
Good to go, okay, then?
Do not pick up any more cases. Do you understand? Okay,
See you Tuesday.
all right.
Yeah, just hang back real quick. Okay, thank you, Judge. We'll see you
Thanks.
Tuesday. Go ahead.
All right. You want to finish up?
Starts in the back. All right, Judge, top of five was an arraignment yesterday and failed to appear.
5002. Who's next?
Next is bottom of 12, Garcia. Except for arraignment, failed to appear to bond from.
Same thing, 5002. Farwa, did you dismiss Gonzalez? You are? Okay, they're dismissing it.
Top of 25.
You want to check outside, see if he's out there? Odolate?
Top of 35 is the arraignment that failed to appear.
2501.
All right, that's it. Top of 35.
Yeah. Mr. Odolate, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 12 days in jail with credit for the 4 days that you've done. You need to understand something very important. This now will reflect as a conviction on your record. It will be there for the rest of your life. Even after you die, it's still there from now on. You pick up any more cases, it's a minimum of 90 days in jail. Do you understand? There are no more proverbial slaps on the wrist. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, to give up the right to appeal. Once you plead guilty, there you can never change this. You understand? Is this what you want to do? How do you plead to the offense of assault? I'm going to find you guilty. I'll call the agreement, sentence you to it. Good luck to you, sir.
Thank
Please
you.
see the clerk. Thank you.
So I think step over here. This is the form I think not the first board of intervention so that people can be court counsel, okay?
Thank you so much. Y'all have a good one.
Thanks, you too. Take care. All right, guys, that's a wrap.